Bonjour à tous et bienvenue à ce webinaire Familles françaises aux États-Unis, quand les choses tournent mal, du déménagement à l'enlèvement d'enfants, l'avis des avocats et des médiateurs, organisé en collaboration avec les consulats généraux de France aux États-Unis. Cette conférence en ligne a pour but de fournir des informations générales aux parents français aux États-Unis, s'interrogeant sur leur marge d'action en matière de garde parentale. Les présentations et les échanges avec les panélistes se tiendront en anglais et nous aurons le plaisir d'accueillir 4 intervenantes et intervenants pour cette conférence: Hélène Carvallo, Melissa Kucinski, Richard Min et Nathalie Sennegon-Nataf. Vous avez la possibilité de poser vos questions aux panélistes dans la partie Q&A et ils répondront à vos questions après les études de cas. Et n'ayez crainte, vos questions ne seront pas visibles par les autres participants. Donc, je vais commencer par présenter Hélène Carvallo, qui modérera les échanges aujourd'hui. Donc, Hélène est avocate française et médiatrice familiale internationale. Elle est admise au barreau de Paris et de New York. Elle dispose d'une pratique juridique binationale étendue à son actif. Elle est avocate conseil pour le Consulat général de France à New York et ses services bénéficient aux Français de New York. Hélène, je te laisse le soin de présenter les autres participants.
Merci, bonjour à tous. Et je rajouterai que je suis également médiatrice sur les questions internationales. I'm going to switch to English to present my colleagues. So I'm very happy to have this wonderful panel with me. I'm starting with Nathalie. Nathalie, she has been a French attorney for about 20 years, and she was also a mediator in France, and she moved about 8 years ago to Florida in the United States, where she is a mediator. She works a lot with family in high conflict and is always, she had a lot of mediation cases with people involving relocation and custody issues. Richard Min, he is an attorney in New York State, focusing in all matters of matrimonial and family law. And he has an extensive practice in child abduction cases. He has represented clients all over the United States and has very recently, last week, argued in front of the United States Supreme Court, which was very interesting to listen to. And last but not least, Melissa Kicinski. She's also an attorney in her legal practices in Washington, DC, and she's also a mediator. She's a mediator for the federal courts, and she has a lot of experience in mediation in child abduction cases, not only, but notably. Thank you very much. And I think we can start the presentation. Nadej, if you can move the PowerPoint. You can go. It's just the agenda of what we're talking about. Change the slide. Okay, so when we are talking about international and intercultural families, what are we talking about? So we have a lot of people coming to us saying we are not married, or we've been married in France. So New York or Washington or Florida shouldn't have any jurisdiction on our situation. We wanted to start this presentation by reminding people that the fact that you're married or not married has no impact on the possible jurisdiction of New York, of American courts on your children if you are a resident of the United States. And the place of your marriage is not important in terms of custody. So even if you've been married in France, living in France for 20 years, moved to the United States 1 year ago, and you have a divorce or a separation going on here in the United States, American judges will have jurisdiction on your situation and on the custody of your children. And that will not be different from the people who have been here for 20 years. The question is, where are your kids resident? Okay. The other thing is that some people come to the United States and they get separated here. Some people are already separated for many years. So in that situation, it's also the same as long as you need to either organize your separation or change the terms of your separation because one person has a change in his or her life, then you need to think always in terms of who has jurisdiction, qui est compétent on the questions of the children, and what can I do with my kids? Okay, you cannot, basically the point of this whole presentation is that you cannot change the residence of your children without the prior consent of the other parent or a court order. Also, so what we're talking about here is people who have at least one child, and that's those families that we're going to talk about. Most of the time they have their connections with different countries. It can be France and the United States, but we also have cases, and I'm thinking of one case that Richard and I worked in the past, where both parents were from a South American country, and one of the parents had moved to the United States with the child. No one was a US citizen. They had no connection to that country except that one of the parents had moved here with the child without the consent of the other parent, and that started the whole case, whether that child should be brought back to the former country or whether that child could remain in the United States. And why do people move? People move for many different reasons. Some people want to move back to France or move from France to the United States because they want to go back to the place where they belong, where they have their roots. Some people move because they meet someone, they start a new relationship and they want to move with that person who is not the father or the mother of their child to a new country. Some people move because they found a job somewhere. Some people move because they have immigration issues. We had a case where a mother lost her visa basically, and her green card was cancelled in the middle of her separation with the father. They were not married. She had to stay legally in the country, or she had to go back to France. It was a very difficult situation because she had no consent of the father to move back to France with the child. And it was completely, it was typically an immigration issue. So you have a lot of different reasons why people need to move back to another country. And that's this process of moving back to the country where you belong to is a relocation. So you have, when you go to court, you have to explain to the judge what's the purpose of your relocation, and the judge has to assess whether he thinks you have grounds to relocate or not. You can change the slide. If you want to jump in, Melissa, or Richard, or Nathalie, please do. So child relocation, what the judge will look at, I put some case from New York, but it's more or less the same idea in all jurisdictions, I believe. I know it's the same in France. The idea is that the judge will not let you relocate with your child to another country if he finds that your motivation is frivolous. If it's just because you want to live in the sun, or you want to live in the most excited city in the world, New York, or you want to move to the city of light, it's not a good reason. You have to have something that's really a very important reason for you to move. And the other thing that the judge will look at, and the main thing that the judge will look at, is the best interest of the child, because what the judge wants is always in custody matters to check that the child's interests are preserved. He's not looking at the parents so much, he's looking at the child. And one big presumption for the best interest of the child is that the child needs to have a relationship to both of his parents. That's the basic. It's in the Universal Declaration for the Child. It's in all documents. The child needs to have a relationship to both of his parents. So clearly, when you ask a judge, or you ask the father or mother of your child, and you tell him, I want to relocate to hundreds of miles away, clearly that's going to change the relationship of your child with that other parent. And unless you have very strong reasons to do so, it's going to be very hard to do. I don't know if Richard or Melissa, as US lawyers, you want to jump in on relocation?
Sure. Yeah, Hélène, I'll add in, just as we're looking at this Tropia case, which is a case arising out of New York and is really the seminal case that describes or outlines what factors the courts look to consider what's in the best interest of the child with respect to a relocation possibility. The most important factor here, and something you touched upon, is the degree to which the custodial parent in the child's life, is the impact of the move on the quantity and quality of the child's future contact with non-custodial parent. And then also the feasibility of preserving the relationship between the non-custodial parent and child through suitable visitation arrangements. So you have to consider, because this relocation law applies to not just international relocations, but if you're living in New York and you want to move to New Jersey or Connecticut or move to Florida or California, they will consider the same factors. And one can imagine that if you want to move from New York to New Jersey, the ability to maintain the relationship between the child and the non-custodial parent will be much easier than if you want to relocate from New York to Japan, which is essentially going to be a 12, 13-hour time difference. And so even through Zoom or video contact, aligning their schedule so that they have, video contact is difficult, let alone having physical and in-person visitation is going to be quite difficult. There was a recent case that came out of New York where the mother was allowed to move to Canada. And the reason for that was largely because the father in that case was not exercising his visitation to the full capability. And that's always going to be one thing that the courts look at. And this is considered to be, in New York, and I think in most jurisdictions, the most important factor, meaning if the non-custodial parent is getting very extensive access, 2 nights a week, 3 days a week, even alternate weekends, and they're exercising it consistently, and they're showing the dedication to maintaining that relationship, courts are going to have a higher burden for the parent who wishes to move to overcome the absence of that consistent relationship. And so you always have to consider, what is that relationship going to look like in the future? If you move to France, for example, you have to expect, if there is a good relationship between the non-custodial parent and the child, that you're going to be giving up a lot of holidays and vacation time, that a lot of that time is going to be devoted to maintaining that relationship in larger chunks, because you're not getting the same weekly or biweekly consistent access. The age of the child also matters. A 2-year-old child is not easy to travel back and forth on their own. A 12, 13-year-old child might be able to more frequently, and therefore it might be easier to maintain that contact. I'll let Melissa take over. I'm sure she has some excellent points as well.
So I agree in New York and in my jurisdictions where I practice, the primary focus is on what is best for the child, but that is not necessarily the case in every single US state. While my observation is it is the case in most US states, there are some places in the US where perhaps the court focuses more on the child's connection with the primary caretaker and whether it's the primary caretaker that may be relocating. The fact is that international child relocation law is one of the least developed areas of custody law in the United States. And therefore, they're some of the most complicated cases in any given family court in the United States, meaning that the outcome is very judge dependent and very child dependent and very family dependent. If you're looking at this from a child focused type of situation, you might also ask, how is it, especially for older children, do we have the child's voice play a role in where they may be living? Whether or not there might be opportunity for a lawyer to be appointed for the child, or for a judge, depending on the courthouse and the judge's competency, to have the child speak with the judge. We also want to look at the respective opportunities for the child. How ingrained are they in their community if they're, say, for example, living in New York right now? Are they playing sports? Are they active in school? Are they doing very well in their current environment? And clearly, the older they are, the more ingrained they are in the community and where they're living right now. And compare that to where they may possibly be moving. Does the new jurisdiction have opportunities to meet their educational needs? Does the specific child have special needs that can be met better or not as well in the new country? Do they have special health needs where they have doctors and are better cared for in one place over the other? How often do they travel to the other jurisdiction? Do they speak the language of the other country where they may possibly be moving? How familiar are they with that community as well? So if we're looking at it from a child-focused perspective as well, we look at how does this look for a child when they're here and then when they are in the potential new place where they may be living.
Yeah, Hélène, I'll add something just to go off of something Melissa said, but from a practitioner's point of view, and Melissa, represents children a lot in custody cases, so she's really good at giving the child's perspective. I certainly have one who represents exclusively parents. I'll give a little bit more from parental point of view and a practitioner's point of view, but it's really important for those who are seeking to establish or to have a relocation to be successful that you essentially are equipped to describe and present evidence as to the child's new life in the foreign country, meaning, where is the child going to go to school? What is the job? Do you have a job offer? What does that look like? What salary are you going to receive? How is that going to impact the child's life? What activities does the child have a prior relationship to the culture, to family over there? Describing that in detail and presenting evidence of that in detail will be much better to someone's case. A lot of times parents come to me and they say, I want to relocate. Well, have you looked for jobs there? No. Oh, do you think you're going to find a job there? I think so. I hope so. Where's the child going to school? Well, there are several options. Well, those types of situations are a little bit premature to request relocation. And it becomes difficult because sometimes you get a job offer and the employer says, well, you have a month. You have to let me know in a month. Well, normally you're not going to get a relocation decision in a month. So there is a timing aspect to this that is very crucial. That requires planning, preparation, and then execution. So I just want to be very clear about that. I'm curious from a mediator's point of view, and Hélène, I just, for you, Melissa, and for Nathalie, just to maybe speak on that, and I'm curious how
I will let them jump in. I just had a question for you about how do you think citizenship of the child impacts? Because I believe that even though it's not one of those criteria, I believe that it's not, it has an impact whether the child is a US citizen or not. And I don't think it's completely neutral for a judge. And I also wanted to open the discussion to the costs of living in the United States. I have a lot of French clients who come to me and tell me, I came here, now we're separated. It doesn't make sense for me to stay here. I can't afford my life here. What kind of argument it is? Is it a valid argument? I will let you address that. And maybe we can open to mediation, because I truly believe that a lot of situations, mediation can help people communicate better on those tricky issues.
Yeah. Can I? Yeah, I just want to say something which is very important on what we hear so far. We talk about couple, we talk about adults, and finally, we see that we have focused on the best interest of the child, because the adults are changing their mind, they are changing the partner, they are changing their job, they want to change the country, they want to go in another country, they want to change their job. But at the moment that they have children altogether, they have to think first in the best interest of the children. And if they don't, it's going to be an issue. So that is, for me, is the base. Sometimes in mediation, the mediation is also used to reason with the people, with the parents, to help them think not in their own interest. I want to change. I want to move on. I want to have a new job, but not in their own interest, but in the interest of the children. And that is not easy to do. That is, for me, it's the base. That is where the mediator can be helpful. Sometimes we need to put forward the risks and the dangers that we make the child run. I just wanted to add that.
Hélène, I'll just, to respond to your earlier question, you know, the immigration status or the citizenship thing, to me, it may play a subjective role or a subconscious role in a judge's decision, but, and I don't, you know, put that aside, but I also think that it speaks to a child's stability in a particular country. The issue for me is that, in my experience, a lot of that becomes speculative, meaning that as long as a child has a certain type of immigration status now, currently, you know, let's say they're here on as a dependent on a visa, maybe that expires in a year or two, and then it's unknown whether the parent is going to be able to extend that visa or whatever the case may be. You know, until that situation arises definitively, it's not going to be, a judge is not going to opine on, well, a child may not have valid status in a year or two, but the judge will say, I'll address that if that were to happen. That also leads, you know, parents to have some level of control, which I don't think the judges want to admit, meaning that if a parent wants to force a relocation and they're the ones who are, you know, receive the visa, then they can sort of take action to have the visa not renewed, right? Or expired earlier. You know, I say all this, but truthfully, simply because the child is does not have legal status in the United States is not a, you know, dispositive factor either. So I don't want anyone to take this to say just because the child does not have legal status, that means that child would be forced to leave through some sort of, you know, pseudo deportation proceeding. That's not the case at all. But I do think that someone's seeking relocation and they point to the fact that they don't have immigration status, which I am currently doing in one of my cases. You know, judges do consider that as part of, you know, the overall best interest of the child.
I think, Hélène, you also asked about the cost of living in the United States, and I agree with you. Almost 100% of clients that come to me, their reason for wanting to leave is, I have no relationship, I have no job here, everything in my life is back in whatever other country, their home country, including better opportunities, better ability to earn, something that they can do in their own profession. And I find that judges, at least in my jurisdictions, keep shifting it back to the child. Yes, it's wonderful if you are happier and more fulfilled and have a better job. That is necessarily better for the child, but judges in my jurisdiction prioritize that child's relationship with a parent above your career path. So consistently, I have found, you know, in many cases, that if the child is well established here in the United States, that it's more likely that child's going to remain here as opposed to relocating with a parent for them to better their own professional opportunities and have more financial stability. This is why child support and other means of financial support do exist in certain situations to help a parent remain here, albeit sometimes uncomfortably, in order for the child to have better access for both parents.
The case I was mentioning earlier that just came out of New York a couple of months ago, the mother was able to relocate with the child, partly because the father was not abiding by the visitation schedule that he was provided, but was also not paying adequate child support. Was not paying what he was ordered to pay, right? And so that's always a factor. You know, just to jump on something Melissa said, you know, being able to work in your own profession, in your home country, like if you have a license in France to practice medicine or do something, may not be transferable in the United States, which may limit your ability to earn an income here versus at home. Plus, if you're French and you have family over there, then you can always lean on family support. You know, childcare, of course, is an extraordinary expense here in the States, especially here in New York. And having, a job and then having someone look after your child can be quite expensive, where if you have family support, back home, then perhaps you can say, well, my mother's there. My mother can watch after the child, or my, brother-in-law can watch after the child. So those are definitely important factors, but it's also my experience. I may or may not have heard this from a judge recently in a relocation case of mine, but, sometimes judges say, it may be in the parent's best interest to move, but the question I have to answer, being judge, is it in the child's best interest to move? And everyone has to understand the distinction between those two things. Now, I often argue, and I do believe that, of course, as Melissa is saying, some jurisdictions consider, what's good also for the primary caretaker, because one can imagine that if it's good for the parents, and it's probably going to lead to benefits for the child, right? If the parent can earn a higher level of income, if the parent can be happier, if the parent is getting remarried, for example, to someone who lives overseas, and can afford the child a more stable, intact family unit, that is also something that I've seen courts and judges consider. But just food for thought.
And I don't want to leave this slide without reinforcing something that Hélène was touching upon at the beginning. The reason we talk about child relocation cases is because here you cannot unilaterally relocate your child, even if you've been the primary caretaker throughout. Even if you have a court order that already exists to say you're the primary custodian and you have more time than the other parent, you cannot unilaterally relocate your child without the other parent's consent or without permission from a court. And so it is very important to know that distinction, to know that limitation, because a lot of individuals assume that because they might be the sole legal custodian or the primary physical custodian of a child, or the one that's always cared for the child, that they have the natural ability to just relocate their child back to the location from where they came.
Thank you. And it's actually the same in France. Under French law, you cannot relocate. I mean, the country is not as big as yours. So inside the country, you're not supposed to, but it's not such a big deal. But you cannot relocate without the prior consent of the other parent or the or court order. We can go to the next slide. So if you do change the residence, move your child to another country without the consent of the parent, of the left behind parent, you're likely doing a child abduction. And there are a lot of different treaties and conventions in the US, in Europe, and maybe Richard will touch upon US, other treaties, but the main treaty is the Hague Convention on the Civil Aspects of International Child Abduction, because both the United States and France are parties to that convention. And that convention, the point of that convention is to put the child and the family in the status quo ante. So basically, you live in France, you have sole custody of the child because the other parent is not able for any kind of reason to exercise his custodial rights on the child. Donc vous avez l'autorité parentale exclusive sur votre enfant, and you decide to move to the United States without the consent of that parent, of the other parent. You're committing a child abduction. And the other parent, the left behind parent in France, will have the ability to reach out to the central authority in France, who will reach out to the central authority in the United States to reach out to you here to ask you whether you're agreeing to bring back the child to his habitual residence. And you may be at the beginning of a very litigious court proceedings for the return of the child. What is the purpose of this convention? Once again, is to move the child back to where he was prior to the abduction and have the judge of that former country, in the example I just gave, France, decide on custody or whatever. So you have a double process. You have the judge here in the United States saying, okay, where is the habitual residence of the child? And that's a big question. Maybe Richard can touch upon that too. Where is the habitual residence of the child? If the judge finds that the habitual residence of the child was in France, then he should send the child back to France and let the parents deal with custody in France. The same in the other way. If you're living in the United States and you want to relocate to France and move back to Marseille with your family and be happy over there, you do that. The same, you're the left behind parent, even if he's French, he can be French, he can be, doesn't matter. He doesn't have to be American citizen. If he's here and he's been residing here, he can go through the central authorities and he can start a proceedings in France asking for the return of the child. If the French judge finds that the habitual residence of the child was in fact the United States, he will send the child back in the United States for a US judge to deal with custody. So once again here, the citizenship of the parties have no impact. The only impact is the habitual residence. How do you understand the concept of habitual residence? You will see in the next slide that it's really a de facto approach, but basically the idea is to really look at the reality of the life of the child. Where does he go to school? Who are his doctors? Who are his friends, etc., etc. And then have the judge of that habitual residence decide on the custody. I don't know if any of you want to jump in. Richard, you want to speak about?
Let me jump in real quick before we talk about the next slide. So I just wanted to add, I think, just as a practice tip, it's really important for people who are in this type of situation, or even if they're contemplating being in this type of situation, that they obtain sound legal advice, and not just from one jurisdiction, from both jurisdictions. Oftentimes I'll hear from a client or a potential client who talks about the fact that they consulted with the lawyer, for in this example, in their French lawyer, and their French lawyer told them about what would happen in the United States with the Hague proceeding, right? And generally they have a good sense of what's going to happen, but there's a lot of nuances and a lot of subtle differences that are really important, especially between a European country and the United States. There are numerous other international treaties and domestic laws that govern the implications of the Hague Convention. Let me put it that way. And so the intersection of the Hague Convention with domestic custody laws, with other international treaties, is really important to understand. And how France deals with the outcome of a Hague case might be different than how the United States deals with the outcome of a Hague case, meaning, as you described it, and generally rightfully so, that custody will be decided, where the child is returned to or not returned to is almost always right. And Melissa can correct me, she's probably more of an expert than anyone on the other international treaties, but is generally right in European countries, because they also have the 1996 Hague Child Protection Convention. But the United States does not have that international law in place. And so our jurisdictional laws, which are state specific, and 49 of the 50 states, except for Massachusetts, has passed it, does not necessarily state because you win or lose a Hague case that the custody will be decided based upon that. So it's really important. I'm not going to go into, because we can probably have another hour talking about the intersection, but suffice it to say that I think everyone needs to, before they make a decision or before they come up with a strategy of how to deal with their situation, consult with the appropriate counsel, both in the United States and foreign counsel, presumably in this case, France, to understand what the implications and their rights and obligations are in those two countries.
Thank you. We can go to the next slide. Yes, so there are a few exceptions to the application of to this general rule of the return of the child to his habitual residence. Melissa, do you want to go through those exceptions quickly for everyone?
Sure, I'm happy to. So if the parent who's left behind in the habitual residence files a lawsuit more than 1 year after the child was abducted, that means that they were removed from their habitual residence or they were retained in this new country. The taking parent can argue that the child is now settled in the new country. Likewise, the taking parent could argue that the left behind parent was not exercising his custodial rights, or they consented in advance to the removal of the child or the retention of the child in the new country, or they acquiesced in a formal document or in some formal way after the child was already abducted to the new country. They could argue that returning the child would expose them to a risk of harm, physical or psychological, or place the child in an intolerable situation. Richard is the expert on that particular exception, having just argued a component of it in front of the US Supreme Court. The taking parent could also argue that their child is of a certain age and degree of maturity, and that the child is objecting to being returned to their habitual residence, not necessarily just stating a preference to remain in the United States or wherever they were now sitting after the abduction, but actually stating that they object. And in addition, the court would find that the parent or any other outside influence was not impacting that child's views and their objection. They weren't impacting or influencing the child to actually say that they objected when perhaps the child didn't independently object. And then the last of those exceptions is that the returning the child wouldn't be permitted due to human rights, which is a very, very rarely used argument by taking parents. The only successful time I've seen that was just recently in a Texas court, where returning a child to a specific place in Mexico would have meant the child couldn't attend school because of the rules that the child who had special needs had to have a parent attend school with them, and that was not a possible option for the child. So I don't know that that would be a very successful argument by a taking parent. So very limited, very narrow. The way our law in the United States is written is that especially at least two of these, including the grave risk of harm one, are very, very difficult to prove. You need a very high burden of evidence in order to prove these to a judge. And so the default position tends to be that the child is typically going to be returned to their habitual residence when at least it's in a US court. Richard?
Yeah, let me just add also, the Hague Convention only applies to children younger than 16, meaning that once they turn 16 years old, then the treaty does not apply. And of course, I presume that France is the same way, but custody laws are applicable here in New York, at least until the child turns 18 years old. So, there's a solid 3 years or so where, you still have custody rights and obligations, but that this treaty won't protect you from that. So there's that to consider as well.
And I don't know that we put this into any of the slides, but there is perhaps a distinction to be made. I keep referencing that you need to file a lawsuit if your child's been abducted to the United States. And that's the truth. That's the way our law is written. When you're out there looking and researching on the internet about what steps you can take in order to seek the return of your child using this international treaty, you'll come across a lot of government offices that are called central authorities. These are offices designated in each country that has become a treaty partner for this particular convention. And these government offices often function to collect information, to gather paperwork, to help you transmit information to the country where the child's now sitting so that they can try to help locate the child or connect you with resources. In the United States, our US central authority that functions under this treaty is the US Department of State. But I will say that our Department of State will not file a lawsuit on your behalf in, say, for example, New York, to try to seek the return of your child. They may try to help you locate a lawyer, but there is no guarantee that they can find a lawyer for you. And you would have to go to the courts and initiate a lawsuit. And especially if you're looking at this slide, you're going to want to do that pretty quickly, because if you delay too long and 1 year passes, the parent who abducted the child has an extra argument to make to not return that child.
Hélène, can you speak on the differences? Because my understanding is that in France, these cases are brought by public prosecutors, correct?
Yes. So in France, that's what I was going to add a few comments, but on the central authority, I think it's very interesting, and that's one of the reasons why mediation may be also interesting for people, because in the US, since you have to file yourself, you're facing a very, very expensive litigation. In France, not only legal fees are cheaper, but also and proceedings are shorter in the sense that you don't go through the same kind of trial with examination, cross-examination, etc. You also have the fact that the public prosecutor is going to be able to file for you. So you can take a lawyer, you can be represented by a lawyer, but if there is an abduction, the central authority will do it anyway. So it's, and you will just add in your information, but the central authority will do that work anyway. So it's a very big difference. And I think it's the case in most of European countries. What I also wanted to add is about the fourth exception: the child is mature and objects to being returned. Although I agree with Melissa that the parent should not alienate the child and have him object. Of course, it's very hard to know, and it's very hard. It's very hard to make sure that the child who is saying, "I don't want to return to such country," is really saying that for himself. Of course, because if you didn't see your parent for many months, you switch. And there is a lot of studies and literature about the fact that a child, when he's and maybe Nathalie, you can jump in on that specific issue, when a child is abducted, he feels he has to choose. So he's going to choose just to protect himself. It doesn't mean that he chooses the abducting parent deep in the heart. It means that he has to do it just to survive psychologically, because it's a very traumatic experience for a child. And also, when we speak about immaturity, there is no age limit, and it depends on the country. Some countries will sometimes hear kids as young as 8 or 9, but most of the time we're talking about 12 years old, I think. I think it's fair to say. Nathalie, do you want to jump in about the children?
Just to add something, that children can always put themselves on the side to content their parents. So it's real in the real life, but it's super real in a conflict, in a family conflict. So of course, what you say is true. You want me to add something about mediation, maybe?
If you want, yeah.
Sure. The thing is, you know that because I have seen so many family conflicts during my 25 years abroad of practice as a family law attorney in France, now that I am in mediation, family mediation, I can see that the mediation can be done not by everyone. So if the people are thinking about themselves and taking decision only for themselves, is not going to work with the children. So that's the point. I think that's the point.
So you mean that mediation is not proper for all conflicts, and there are some parents who are not able to address certain issues in mediation?
Unfortunately, it's the case. I don't know, Melissa, what you think, but yes, for me, what I see.
But you also said earlier that sometimes mediators can help parents start seeing things through different lens and start learning to see what is best for their children. So you never know really when the parents will start looking for what is best for their children. And I think trying mediation is always a great, it's always a good exercise, and maybe it doesn't lead anywhere, but it's always a good exercise to try to hear the other spouse, the other parent, and try to hear the child.
Sorry. Mediation should be done at the beginning, of course. Mediation is always first used to re-establish the dialogue between the two parents, of course, and it can be done at any moment, before, during, after a divorce, at any moment. But for that, you have to have the two parents concerned about the best interest of the children. If they are concerned about themselves, only about themselves, they are not going to go in a mediation. For me, that is the point. I don't know, Melissa, if you share my view, but
no, I agree with you completely. Sometimes it is hard, though, to refocus. I mean, if you are a parent and you are desperate to see your child and you're living in a different country from the other parent, you may feel that it's very important that your child spends significant time in your country with you. And I've had this situation on multiple occasions where one parent is feeling that, well, I will give in. If I'm going to allow my child to be considered living in the other country with the other parent, I want so much time that it seems in a way sometimes impractical, especially when children get older. They're in school, they have friends, they have activities, and their parents become a much less important person in their lives. And I found that, yes, it's important for that child to spend significant time with both parents, but sometimes it's easier to lose sight of the fact of what's happening in your child's daily life, and the fact that they have their own separate life that is going to be very disrupted if they're traveling back and forth in many ways. So that is a big difficulty that I've had in how is it I, as a neutral person, have both parents step into the child's shoes and see it from their perspective.
Think of your child first, increasing the weight of the voice of the child. It's the base, of course. And don't forget that the mediator does not advise in terms of law. He is neutral, he is impartial. His role will be to help people find the solution themselves. So the solution is not something that the mediator is going to give to people. So they have to find the solution themselves, because they know their children. They know exactly what Melissa said. They know the friend, they know their habits. So we can help as mediator. We can help them to, again, reestablishing the dialogue between them. But we are not here to give them the solution. They have to find by themselves, because this is the role of the mediator in my concern. But I'm sure Melissa is agree with me.
Can I ask you a question, actually, that I'm curious about now that you're speaking about the role of mediator? When you say it's not the role of a mediator to sort of give their opinion on the law or apply the law, it's really about trying to, increase the dialogue and stuff like that. Sometimes, just from a practitioner's point of view, when I'm representing parents, especially in these international cases where not a lot of the lawyers know what they're doing, truthfully, I find that there's a lot of, let's say, information imbalance sometimes on the law, where perhaps I think I'm telling my client, you may win, you may lose, here's how I see the case, but perhaps I have the feeling that the other side has an unrealistic expectation. And therefore, settlement discussions are difficult, because if they think they're definitely going to win, for example, maybe they have no interest in discussing settlement or whatever the case may be, where if I, perhaps sometimes as a more seasoned attorney, knows that their chances are not as good as they think they are, and they should be more open to mediation and to settlement discussions, sometimes I always hope, even if it's not the case, that I hope by going to mediation that perhaps they will hear a different voice than their own attorney, and they will maybe think that, oh, I should consider settling because I thought I was definitely going to win this case, but now I have a feeling that maybe it's not so certain.
If I can jump in on that question, because I think it's a different, it depends if you're doing a mediation in a child abduction context or not. If it's an international context, I agree with Nathalie, the mediator needs to be neutral, impartial, blah, blah, blah. He shouldn't give legal advice. In the child abduction context, it's a little different because you're facing mediation that has to take place in a very short time, very short period. And although the mediator should not give advice, he may put on the table a little more information, I think, and that's the experience I had talking to some mediators in France also, and they say that they try, because you're in such an imbalance of power, as you say, and sometimes one parent truly believes that he is in the powerful situation and he is not. It's important for the mediator to, at the pre-mediation stage, push people to go to mediation. Once the real mediation, once the mediation starts, you let them make their own decisions, but to have them come to the table, you have to have them understand that they also have risks and they also may get something out of the mediations. I don't know, that's what you think about that.
The thing is, you always can inform them, but you can't advise them. That's the point.
Should we change the slide? Thank you.
I want to say in addition that, you know, as an attorney, I was an attorney. So sometimes I'm very tense to give some advice, but I transform my advice as an information. Like if you go that, if you do that, if you do that, you can see the law is like that, etc., etc. But the word advice, I'm going to give you an advice, we can't use it. It's not at all the role of the mediator. We have to keep the neutrality and the impartiality. It's the law.
It's the system, yeah. So we did 2 slides about the benefits and disadvantages of either court proceedings or mediation in child abduction cases and child relocation cases. So basically, the advantage of going through a court proceeding in a child abduction case is that you're supposed to have very quick results. According to the convention, the judge is supposed to give an answer within 6 weeks. So even though he may not be able to do it as quickly as those 6 weeks, that's the purpose. So it's really supposed to go very quick. And that judge, as we mentioned before, is going to put the child back to the habitual residence where he came from and resume the status quo. And then the parents will need to do another proceedings in the original country for the custody case. So basically, that's one of the disadvantages, is that you're going to have 2 court proceedings, one for the return of the child, let's say in the United States, to have the child returned to France, or the contrary, and then one in France to have the French judge address custody. The other disadvantage is the costs. We touched that issue before. In all events, it's going to be a very expensive process. And another disadvantage is the fact that we are not going to address your culture. We are only going to address the fact that your child should be returned to his habitual residence. So there is no sensitivity to the specificities of one culture in these court proceedings. In mediation, in contrast, the mediator can be trained to develop sensitivity to different cultures because we know that people speak differently. And I think anyone who has been living in another country knows that, for example, French, we always start speaking a lot before we get to the conclusion. It's the way we form our brain. And whereas an American, I was so surprised when I arrived in this country and I read the first motion papers that people start with what they want and then they develop. I was like, this is amazing. No one would ever do that in France, because you think that you have to explain how you get to that conclusion. So you explain all that could be done and then you get to your conclusion. Here it's the difference. Also, you have some countries.
Hélène, can I make you feel better for a second?
Yeah.
When I was practicing for my Supreme Court argument, everyone kept saying, Richard, you have to start with what you want and then talk about how you got there. I'm similar to you. I always go the roundabout way. I always talk about the reasons and then end with what I want. So don't worry about it. It's okay.
Maybe you're a little French, you see. Yeah, I think, so there are a lot of different cultures. I mean, I was just doing a very, very interesting training on international and intercultural mediation, and you have people coming from other countries where, you know, looking in the eye of the other person doesn't mean the same thing in one culture and in the other culture. Saying what you want, some people are, you know, some cultures are good in saying what they want and what they choose. And in some countries, you have to ask your community about what is best for you, etc. So you have a lot of, in mediation, you may be more able to address the depth of your culture and which is also the culture of your child in a way. So that may be, that's a better avenue to address those issues. And also in mediation, you can address not only the specific issue of the residence of your child, but all other issues. You can be much more creative. You're not, because the mediator is not giving you legal advice, you can be creative, you can decide more or less what you want. I have a case, it was not in mediation, but it was a settlement where people decided to have 1 year in France, 1 year in the United States. You know, I don't think a judge would order this kind of thing because it's pretty strange, but if it's good for the parents and the child, why not? So you can be much more creative. The disadvantage of mediation is legal enforcement. I mean, it's not a disadvantage, but you really have to make sure that whatever you get, the agreement you're getting in mediation, you have to double check that this is going to be enforceable in both jurisdictions. And I mean, the frustrations linked to the potential rush to mediation, Richard touched based on that. I think you have some people who will say, okay, I will let the parent, the taking parent keep the child, and so we can, you know, have a better relationship, etc. And then after the mediation, there are some examples of people who come back and say, finally, I felt a little frustrated, I felt a little rushed in this mediation process. So it's always a tricky issue. What do you agree? Do you have time to really know what you're going to agree to? Clearly, frustration you'll get also in the court proceedings, because you always get frustrated, I think, out of a court proceedings. It's never, you know, it's never perfect neither, but it's mediation may, I mean, especially in child abduction cases where you have like a very few days of mediation, it may not be so ideal as we would hope it is. I don't know what you think, Melissa and Nathalie.
I just want to add something about mediation, that in mediation, you always can take your time. As I always, you're not in a calendar like you are in the court. So I always say to my client that you're not getting married in 5 minutes. You are not going to get divorced in 5 minutes too. You can take your time. You can go in a mediation, make a stop, come back, and see what's arrived. For example, in mediation, what we always see is that there is always subjects in a separation, in divorce, which we can find friendly solutions. Not everything, of course, but some points. And the mediation, it's very helpful for that. That is not the case of the court.
But in child abduction cases, I don't think you have so much time, and I think that's one of the frustrations.
Yes. Of course.
Yeah.
When the child abduction, of course. But you were talking about the benefit of the mediation. For me, the benefit of the mediation is to help people to think about, take the time, not be in a rush to hire an attorney to go to the court. And of course, it depends on the case, of course.
I see that the court proceedings and the mediation run in parallel and intersect in many ways in Hague abduction cases, at least. I think the court proceedings are intended to be expedited and move quickly, so the mediation process will often move quickly, and they sort of keep each other in check and balance each other out. Sometimes you'll get judges that will give some preliminary views on the case that could even help in negotiating during the mediation. You could get what Richard was describing as more evaluative mediator who, while they're not giving legal advice, may have significant experience with the type of cases that are pending in court that could give observations of what they've seen throughout the years in the cases. And so I think having them run in parallel, it can be frustrating. It can be, it can be very quick, and you do have to take advantage of moving on that quick timeline. But I think that they can work in tandem.
Can I ask a question, Hélène, about when you say the benefits of mediation, the broader scope? For those who have mediated cases, have you ever come across a situation where, let's say it's an international custody or relocation or abduction case, where one party at least wants to only mediate that single issue without discussing broader underlying custody issues or support or the divorce or financial components? And how does that play into the success rate, so to speak, of the mediation process?
I can answer that. So yes, there are the rare circumstances where, say there's a Hague abduction proceeding, the parent comes in, they say, I want to mediate only whether the child's going back or staying here. That's it. And that's not common. Most parents want to say, okay, if the child is physically situated in one country, I also then want to discuss their travel. I want to discuss how we're paying for it. I want to discuss when they're going to see both of us. But if they're looking at that one singular option, I do think it is more difficult to mediate. I've had situations where if that is the one option, we often can't bridge that. We go in and we say, okay, well, if the child is with you, this is the schedule we envision. If the child is with the other parent, this is the schedule we envision. We both would want for each other what the other wants, but we just can't decide where the child's going to live primarily. And they throw that one issue to the court in the Hague Abduction Convention case. And once the judge decides child's going back or child's staying here, then they have a rest of an agreement to fall into place. I've seen that. I mean, sometimes you have to get creative. Sometimes if you cannot resolve that issue that is pending in the Hague abduction case, but like Natalie said, you can then mediate afterwards. Sometimes judges in those cases say, the child's going back and they don't specify all the logistics. So you can then go to a mediator and talk about, well, when is the child going back? How can we afford it and pay for it? Maybe I am the parent who took the child. I want to go back as well. Can we negotiate some of that? If you can't resolve it in mediation, the child's still ordered to go back by a court, but you can talk through even those issues after you have that court hearing.
Yeah, I'll just add something in for a practice tip, having been involved representing parents in some of these international mediations. But when you do broaden the scope and you're talking about underlying custody issues, support issues, and then to talk about one of your disadvantages, Hélène, about the mediation, the issue of legal enforcement, it's very important that you have lawyers consulting you here in the US and abroad.
Yes.
Because if, for example, part of the case is resolving because the child's going to go back to France, and the child is obviously here because we're talking about situations where the family is in the United States. You know, I might be representing one of the parents. There might be another lawyer, let's say Melissa or Natalie or Hélène is doing the mediation, but then we're going to need to know how to draft this in a enforceable order in France, because that's where the child's returning to, unless it's going to be a US order, and then there's other concerns, right? So either way, you know, you need to have a lawyer on both sides of the pond, you know, advising the parties and, you know, being part of the drafting process as well.
And I think that was part of Helene's point, the issue of legal enforcement. One of the disadvantages of mediation, you can reach this full, robust agreement. Say you have a Hague abduction case pending in New York federal court, and you reach this agreement in mediation. It's wonderful. It not only talks about where the child's going to live, but the schedule and their travel and everything. The court in New York might not have the authority to take that agreement and make it a binding court order. You might have to take it to France. So you really do need lawyers in both jurisdictions to consult with you, perhaps even participate in the mediation. Mediation is a flexible process. So, you know, you can certainly talk to your mediator and your lawyers about how to structure that process and who to include in the actual sessions and the pre-mediation. But I have found that the more successful mediations do have the lawyers included and lawyers from both countries.
Yes, and if I can add something, the mediator can be the link between the two attorneys.
Exactly.
Because it's going to stay neutral and impartial, as we say before. So it can be the link between the two attorneys in United States and abroad, or vice versa.
And the mediator may have a network of professionals around him or her who he can, because people don't know who they would take as a lawyer. And as Richard said, you know, if you take a lawyer who tells you, oh, no problem, just do whatever you want, you're fine, it's not going to bring you anything good. So the mediator may also be able to guide you and help you find proper legal counsel. We can move to the next slide, which is not so different, but we did the same approach for child relocation. I think here what Nathalie was saying before about the fact that you can take the time you need in order to address the relocation of your child, I think here it's really true. The mediation is a space where you can have time. You're not under the emergency of a decision from the judge, and you can, you know, you can take more time to see what's best for your child. I personally think, that's very personal, I think that a lot of people, French people in the United States, they would really benefit, not only them, but also their US spouse, they would really benefit from a mediation, because that would enable the US person understand why that person feels so lonely here, desperate here, and why she or he wants to move back. Doesn't mean that he would move back, but sometimes just to have people hear what the other person feels is not the solution, but it's the beginning of trying to understand what's best, including for the child, because to have one parent completely depressed here or there is also very, very hard. And I think a lot of mediators express that when some things are heard by both parents, most of the time, I think, Nathalie, you have a very beautiful story during COVID. When people start listening to each other, they sometimes start understanding the other point of view, and then they may be able to also move from their positions themselves. So I think mediation in child relocation cases would be a good way to start this kind of process if people are willing to move. Yeah, I mean, I put the slides here. I don't know if any of you wants to add anything to this slide.
No, because you talk about my experience. It's real that during the COVID, I have a lot of beautiful experience, like the mediation avoid a lot of divorce, because people try to learn how to live all together with the children at home, with the husband at home, with all the computer turned on in every room of the house. So yes, we all have, I think, good experience with. Sorry. But again, the mediation, it's very, you have your time. You're not in a rush. That's why I wanted to say before, like, you're not getting divorced in 5 minutes. And during the COVID, we all learned to take our time, to take the time to take decision, to take the time. This is my point of view.
Thank you. Maybe, I don't know how many slides we have before the case studies, but what's the next slide? Case study, that's perfect. Okay, so you can go to the first one, please. Thank you. So we put several case studies here that I think will go through most of a lot of situations. So here, Marie is a French citizen. She is a university professor of economics in Paris. She's married to Jean, who is a medical doctor in Paris, and they have 2 children aged 2 and 4. She has a 1.5-year contract to work for a think tank in New York. She takes a sabbatical year from her university position, and they all move to New York. And after 1 year, Marie decides that the marriage is not working anymore. Jean is in Paris attending to his practice. She changes, during that time, Marie changes the locks on their home, hires a lawyer to file a custody lawsuit in the family court of New York State. And she's seeking for primary custody and the opportunity to remain in the United States. The think tank has offered her a contract extension of another 12 months. Richard, do you want to go into it?
Yeah, I think one thing we didn't do earlier on, and this is a good opportunity to do so, is to talk about the concept of habitual residence.
Yes, it's true.
Convention, right? And this case study, I think, is a very typical example of what maybe a French and American intercultural family might look like. Obviously the situation is both parents are French, but you can imagine a situation where one of the parents is American, one of the parents is French, and they move here temporarily. In this type of situation, the question is going to become if this is a Hague abduction case. Now, it's not a case where a parent wrongfully took a child and left in the middle of the night and left the parent behind in France and kidnapped the kids to the United States. This is a case of what we would call potential wrongful retention of a child, which means that you had an agreement to be somewhere for a specific period of time, and then you were supposed to go back to France, but then one parent is unilaterally deciding not to return the children back to what they presume is the home country. But the question comes down to, is France the home country, the country of habitual residence, or has the United States now turned into the country of habitual residence such that the children do not have to be returned? It's really difficult based upon these facts to say what a court would likely do. A couple of years ago, the United States Supreme Court in Minaski versus Taglieri defined, or sort of defined, what habitual residence is and listed out, stated that habitual residence should be determined by the totality of the circumstances, which means that courts should consider common sense approach to what the child's home is at the time of the wrongful removal or retention. That considers, what did the parents intend? How long have the children been in that country? What are their connections to that country and the potential foreign country? Are there any, coercive control or domestic violence elements that play into the parties' intentions? Here, clearly, based upon the facts that are laid out, the parties intended to stay in New York for 18 months. What it doesn't say is what their plan was after those 18 months. Oftentimes people say, well, we plan to be here for 18 months. Clearly we were going to return to France. But that's not always the case, because sometimes you have options to extend work contracts. Sometimes, they may disagree as to what they were going to do after 18 months. Those are very important factual distinctions to make. I just had a case between Iceland and New York where the parties moved to Iceland. The mother claimed that it was only for 2 years. The father claimed it was for at least 2 years. And then they would decide whether they stay in Iceland, whether they go back to New York, or potentially whether they go back to Mexico. And the judge in that case decided that the habitual residence was Iceland after, I think, 18 months or 2 years, because they had no definite plans for what the future held. And that at the time of the wrongful removal, the children's home was in Iceland. So after these 12 months, where was the children's home? Did they keep their house in France if they had a house? Did they sell it? Did they rent it? That would speak to some extent as to where the children's home was. Was there discussion about extending the work contract? Did Jean, who's a medical doctor in Paris, did he work remotely? Did he continue his employment in Paris? Did he quit his job? Did he start working in New York? Those are all very important factual things to consider. There's no definitive answer, in my eyes, as to what the answer would be here about the children's habitual residence. If I was representing Jean, I would certainly make the argument, well, they had an 18-month agreement, and 12 months is not long enough to establish a new habitual residence. But for children that young, from 2 to 3, from 4 to 5, especially 4 to 5, they start making these attachments, right? You're likely in pre-K4 school year or this year before kindergarten. You're probably having play dates. You're probably meeting friends that you're gonna, want to spend a lot of time with. So, there's a psychological component as to what a child's home might be. I don't know if Melissa or Natalie have anything they want to add to that analysis.
No, I agree. I
was going to add in this particular fact pattern, Marie has already started a lawsuit in the New York family court. If Jean puts her on notice that he is going to pursue return of the children to France under the Hague Abduction Convention, then the local family court is not going to proceed until that Hague Abduction matter is resolved and determined whether the children are going back or staying. And even then, as Richard was saying earlier, the New York court would still have to make an independent determination as to whether it was the proper place to hear a case related to the custody of these children after the Hague Abduction case is resolved. So just because Marie has been in New York for a while and filed a custody lawsuit, if any of you are talking to lawyers as of right now, you probably have in your mind 6 months as as this time frame where you can file a lawsuit for custody in the United States, but that's not necessarily cut and dry. You really need to talk to a good lawyer who understands all of the nuances of jurisdiction and the Hague Abduction cases as they proceed and intertwine with one another.
Right, and in this case, just because Jean, let's say he brings a Hague Convention case and says the children should go back to France, and for example, let's say he loses, he still can apply for a relocation of the children in the New York family courts, assuming they take jurisdiction, which, if he lost a Hague case, I presume that they would for the purposes of this hypothetical. He could still seek relocation and say it's in the best interest. We had an agreement, this is where the children have all their family, where they've culturally adapted to, let's say they came to New York and they were going to the Lycée Français in Manhattan, right? And let's say they were going in the French curriculum, and let's say they, did not speak that much English, right? There's a lot of little details there that might be relevant to a relocation case or to a child abduction case as well.
And likewise, if the children are returned to France after the Hague Abduction case, and if the French court determines it has the authority to proceed with a custody case, there's nothing to say that Marie can't go to the French family court and ask for a relocation back to the United States. So the Hague Abduction component of this really is just step one. And the custody case is really the guts of where you're going to resolve what's going on for this child.
Well, Hélène and Natalie, can I ask you a question? In this hypothetical, would Jean have the ability, even forget about whether it's enforceable, but would he have the ability to go to the French family courts and ask for some sort of custody order?
So under French law, you have a lot of European conventions and regulations that are similar to UCCJA in the US. You don't have this 6-month period, but you have this concept of residence. The issue is when the country, when the other country is not a member of the European Union, like the United States, the France, for example, will apply not the EU regulation, but its own domestic law. And under French domestic law, there is a provision that French courts can take jurisdiction both in a divorce and in the custody matter if the parties are French, if one of the parties is French. So yes, they can take jurisdiction,
Right.
but you know, what are they going to do? Seriously, the French judge is going to say, what can I do? The same, he's going to, I mean, because you can also have two custody cases start, one in New York, one in France, and the French judge will most probably stay the case because the children are not present. So he knows that it's a little.
Right. So, right, as you were saying, if this was a case between the France and Germany, they would apply the 1996 Hague Child Protection Convention, right, on jurisdiction.
They would apply regulation Brussels 2 bis.
2A.
I mean 2 bis, 2A.
Yeah.
Right.
And they could apply the convention, but they have the Brussels 2 bis, which is actually a very, I mean, it's within European Union, but it's a very, very strong regulation, and it goes further, I believe, correct me if I'm wrong, Melissa, than the Hague Convention, because it really goes in, you really, I think the reasons why you wouldn't send a child back are much more limited under the European regulations, if I'm not incorrect.
And in addition, in this first case, all the members of the family are French. They don't have, they are all French. So they are in United States only for the work of the mom. That's it.
Yeah, so I think this was, you know, I asked this question assuming that the answer would be that they could under domestic law, because I do think it's important for anybody listening, you know, if they consult, oh, I'm French, I'm going to ask a French lawyer, I want to file for custody, I'm French, I want access to the French courts, that you may well have access to the French court, but as Hélène says, it doesn't really matter because it's not might not be enforceable in the United States. So the French courts can do whatever they want in theory, but the question is how it's going to intersect and relate to the proceedings that are ongoing in the United States. So that's just trying to reinforce the importance of having lawyers in both jurisdictions.
And the US judge may take it may not be happy that you're trying to escape his jurisdiction. There is a lot of psychological aspect
from your lips to many of my clients' ears, hopefully, when I try to tell them don't file things abroad when your kids are here. But
yeah. Maybe we can go to the next case study. Melissa, do you want to go through it?
Sure. So Elsa and James are US citizens with 2 young children, again, ages 4 and 2, both were born in the US. And they have this grand dream of moving to Europe. So at the end of 2019, the family spends a few months in Paris, which convinces them even more that they want to stay there. COVID, of course, hit in 2020, and the family temporarily moved back to the United States into one of the 2 homes that they have. In September of 2020, then they moved to Italy because there is a job opportunity, and their hope is then to use Italy as a landing point where they then go to France. In September of 2021, a year later, they moved to Paris on a long-term visa, and the children start school there. At the end of October 2020, just about a month later, the father takes the children back to the United States. He then files for divorce and custody of the children, presumably there in the United States. So the question is how to help this particular family. I can give some of my general thoughts right here. I mean, according to this fact pattern, the family has not lived in the United States since about September of 2020, so just over a year. There is, according to this, no existing agreement between the parents or court order related to the custody of their children. The last agreement between them, which was informal, seems to be that they would be living in Paris and they were there on long-term visas. Long-term to me indicates that there might not be a particular end date, or at least it's for several years. They enroll their children, so they clearly plan on being there throughout the school year, which is a more extended time in Paris, and they've been talking about living in Paris for years. So the question really is, what should happen with the divorce and custody case that's filed in the US? And presumably Elsa might want to pursue a Hague abduction return petition to repatriate the children back to France. If she does so, she would certainly need to do that by filing a lawsuit in the United States and need to, and under these facts, prove that France has become the habitual residence of these children. Richard.
Yeah, I mean, I would say, and I distinguished this from the last case study because I strongly believe that in this type of fact pattern, the habitual residence would be France. Because first, you have a fact pattern that presumes that since 2019, they've been making many efforts to move to France, which shows that their intention is not short-lived, that it's been going on for years since the children are very young. They have been bouncing around between Paris, Italy, and the United States, which shows that they don't have stability, at least in the United States, which means that that's an argument against why the United States should be an habitual residence. And it's important to note that at least in the US, there is a presumption, so to speak, that children should have an habitual residence. So one might argue and look at this case and say, well, the children really have no home, right? There's no home in the world. They've lived here, they've lived there, and they have no stability anywhere. But courts are really loath to make that type of finding because then the Hague Convention doesn't really apply to them at all. The Manaski case sort of indicated that that should not be done, though they did not say that that's a rule, that a child cannot have an habitual residence. But I think the implication is that a court would likely find in most scenarios a child does have habitual residence. Here, they clearly moved with the intention to make Paris their home. You know, some of the facts that are against that, of course, they seemingly have two homes in the United States. We don't know what their situation is in Paris, but I do feel confident that when comparing to some degree the United States versus France as the, you know, intended home of the children, that Paris would be the habitual residence.
And again, if there's a Hague abduction case started, presumably nothing is happening in this divorce and custody suit while that's pending. But separate from the Hague abduction case, if you're looking at this divorce and custody suit, specifically the custody piece, which we're talking about today, there is a question as to whether that should even go forward anyway. You know, we were talking about in the last slide that there is some significance to 6 months under US law as to the length of time that a child is geographically located in a specific jurisdiction that would give a US state authority to then take up the custody matter for that particular child. In this particular case, the family last lived anywhere for 6 consecutive months, a child and a parent in Italy, but no one lives in Italy right now. The children only lived in France for probably 1 to 2 months before the children were back in the US. But again, the children hadn't lived in the US for over a year with anyone, even alone. So the question is there are no real 6 consecutive months with a parent in any particular place where someone still lives, or particularly where the children still live with a parent. So we're looking perhaps as to whether the US even has any significant connection to the children to warrant a US court to even pursue or resolve custody over these children. And that might be a tenuous argument. So, you know, it gets a lot more complicated than that, but you need to speak to a skilled family lawyer who knows the multi-jurisdictional component to do this analysis before you even file a lawsuit, because certainly you don't want to start filing lawsuits that can get extremely expensive very quickly if you end up filing in the wrong place at the wrong time, because that could prejudice you in the long run if it's the wrong suit. So you need to really talk to someone before you do that.
And in the US, there is the fact that they are US citizens, those children doesn't enter into play, correct? We can go to case study number 3. Richard, you want to go with?
Sure. Cécile is a French citizen residing in France as a teacher. In 2016, she meets Alex, a US citizen who is in France to work as an English teacher, and they get married and they have twins. In July 2018, they moved to Ireland. The wife is unhappy and the husband is abusive. The following year in March, the mother and the twins go to France on vacation and decide to stay there. The father starts a custody case in Ireland, giving him temporary sole custody of the children, and asks for the return of the children, presumably in France, which he wins. The children are then returned to Ireland. The father disappears with the children, and the mother believes that he came to the United States, where he's originally from, with the children. This case sounds familiar. The fact pattern sounds very familiar to me and Hélène, I think. So, I think this is a situation where I think we can talk about it rather quickly. The mother was obviously found guilty of child abduction. The father got a temporary order, but there's no indication that he got anything permanent. And he disappeared with the child. Now, a case like this, where a court has already determined the habitual residence of the children to be Ireland, typically will follow that family around, meaning that since the father has subsequently abducted the children from Ireland to another country, the United States generally, absent some finding that the country that made the initial determination did not follow the proper interpretation of the Hague Convention, will simply almost rubber stamp that determination in a way. There are some facts that might alter that, if the children, depending on how long it took to discover the children and whether the children's situation has changed. But in this type of situation, Ireland would continue to be the habitual residence of the children. And if the mother were able to locate the children in the United States and start a Hague action, the likelihood is that she would be successful and the children returned to Ireland, which I think was the outcome of this hypothetical situation.
Yeah, I'll jump into that because I wanted to ask you guys what you think. What is the sanction of a child abduction? And I think people, it's also important to understand that when you do a child abduction, it's not only that the judge will do the status quo ante and he will return the child to his habitual residence unless he finds that one of the exceptions apply. But also then you have the custody case to face in your original country. And I guess it's different in each country and it depends on the judges, but what would typically a judge decide in terms of custody when one of the parents has been found guilty of child abduction?
I think it depends, as you said. Here you have a situation where the father was abusive. So in a way, even if the mother abducted the child and even if the abuse was not sufficient to raise and satisfy the grave risk of harm exception, I think a court would not look to punish the mother, so to speak, for taking the children because she was trying to flee a violent situation. Again, if a parent does not have that sort of element, then perhaps they would be, I don't want to use the word punish, but perhaps that would be a factor in an ultimate custody determination. But we have to remember that it's not about punishing a parent. It's not about rewarding a parent. It's about what's best for the child, right? So you always have to focus on the parent-child relationship. And if that, to some extent, I think the court is going to be worried about a re-abduction, a future abduction. So there might be some preventative elements in any custody order, such as a restriction on international travel, some other protective measures such as posting a bond or only traveling to certain countries or for certain periods of time. But I don't think generally in my experience that courts have gone out of their way to punish or issue custody orders simply because if one parent has engaged in abducting practices previously.
We can go to the next case study. Nathalie, you want to speak about it? We can't hear you. You're mute.
There is so much noise around me right now, so I let you. I am not in my house, as I told you guys. I'm sorry, but I am in a place, and they are starting music just around me, just very close.
We cannot hear. No, we can't hear it.
Okay, that's good. Okay, so let's move on this case. So Nathalie, so it's not me. I was not me. And Warren, my husband's name is not Warren. Are married and have a 2-year-old child in France when they decide to temporarily move to the United States for 2 years for temporary work harassment. While in the US, they have twin girls. After the end of the 2 years, one parent wants to return to France as planned and the other does not. So this is very familiar for us, of course. And in this case, we can, as mediator, make something at the beginning of this kind of situation. But it's true that if one of the or the other wants to go, even the mediation cannot let them put them in United States if they don't want to stay in United States. So usually in the mediation, we put the accent on, again, the best interest of the child. We just have to discuss with them to help them to find where is where the children have the use to go, where they have the more links, the more habits, where are their friends, where are their family. But it's not easy to resume this kind of situation and conflict. You're sure you don't hear the music now? Surprise. It's okay. So, but in this kind of situation, we can try to reason with the parents and help them to find solution, to discuss, to put the light and to be focused on the children, of course. But it's, if they want to go back to their country, as I told you from the beginning, we have to I also say to people that children are not luggage. They are not our luggage. At the moment that we can decide for ourselves when we are single. At the moment that we are parents, we have to decide and to have l'accord, comment dire,
the consent. You can switch to French if you want.
The consent. No, but I know that Richard is not fluent in French, so.
No, but
okay. So no, but at the moment that we are, each time you don't want to take care and to wait for the concern and the consent of the other partner, of the other, you decide from yourself, you're going to go in a way that you're going to find issue, of course. So first, try to have the consent of the man or the woman with who you have children, is the base. What can we say in this kind of situation?
And maybe come to the table of mediation and try to understand why that parent wants to move. And
it's typically the kind of,
why you want to stay, because it's the situation legally, as Richard was mentioning before, you never came here forever. So maybe there is a reason, maybe, the parent who's been following, there is often a parent with a spouse who is following the other spouse. And so having both of them come to the table of mediation and explain why one wants to stay, why one wants to go back. And maybe, as you mentioned before, you and Melissa, bringing back the question of the child, the voice of the child. Either the child can speak to the mediator sometimes, or the parents can, they can have an idea of what the child really wants, and they can, go back to to the interest of the child and maybe defocus of their own interests. Maybe it's the way to approach this kind of situation if there is no emergency again. That's the...
It can be only a crisis. During the COVID, for example, some people lose their job. Some people have family abroad and old parents, they were sick in their country, so they were afraid. They wanted to go back to France, and because of the situation of the COVID. So we have seen a lot of situations like this during this hard time that we all have. But it can be like just they change the job, they don't feel comfortable in their new job, they want to change, they miss their family. It can be a moment that they feel not good. And at the moment, in this kind of situation, the mediator can help. As you say, Hélène, on s'assoit à une table, on discute, on prend les gens, on voit si c'est quelque chose de une crise temporaire ou si c'est vraiment une crise de couple définitive, et on essaie de voir si on peut organiser les problèmes et les étapes and the decision to make for the future.
I have a question that maybe we can, you wanted to add something, Richard?
Yeah, I think there's a couple of, issues in this case study that I think are important to point out. Number one, you should note that the older child was born in France, but the younger twins were born in the United States, which makes an abduction claim very difficult when it comes to habitual residence, because in the United States, I cannot imagine, and there have been some cases that have opined on this exact type of issue, but children that have been born and lived exclusively in the United States, a court will find that the United States is the child's habitual residence, regardless of what their intentions were for the future. So it's going to be very difficult for the parent who wants to return to France to have the younger children return. You also have the issue of splitting up children, splitting up siblings. In both relocation and custody and child abduction cases, courts are loath to split up children as a final result. So in this type of case, I do believe that the ultimate resolution is going to be found in the custody courts, not in the child abduction courts. And so it is a very difficult situation. And obviously, as you can imagine, I was looking at some of the earlier case studies, children 4 and 2 are some of the situations that we've presented. But you can imagine if you have children 4 and 2, you might have another child on its way, right? Or in a couple of years, have another child born in the United States. And then your entire circumstance will be affected by that new fact. Here also, the 2-year temporary work reassignment, you might envision that there is also immigration issues that accompany this fact pattern as well.
On peut ajouter aussi, Hélène, that we can have maybe that with the children and the impact of the situation to the children, nothing is definitive. We can always move on. We can always, you see, the judge or even mediation, quand il y a des accords dans une famille or whatever, we can always go back, try this situation, this settlement during like 6 months, 1 year, and see how is it going. And if there was a decision. C'est important parce qu'en France, on peut toujours revenir sur une décision de justice quand il y a un élément nouveau.
The same in the US.
And it's the same in US. So that is very important. Something is changing in the life of the parent, or something is changing in the life of the children. One of them can be sick, one of them can be can have to travel or to go back to the country for the job or for a medical problem, a medical issue. So we can always go back to the court or to mediation if something changed in the life of all the members of the family.
Yeah, I think both in the US and in France, you have this idea that a custody decision by a judge or by the parties will never be until the kids turn 18, because life happens. And if something happens in their lives, one of the parents can go back to a court. I think one of the big differences between our two countries is that in France, the fact that France once had jurisdiction on custody doesn't mean that France will keep jurisdiction on custody forever. In the United States, you have different rules in terms of custody, and who the judge is to make the first custody decision has a big impact on who will the judge be for the next decisions. I have two questions, so I wanted to just address them maybe now. One, which is a very interesting question, was what's going to happen in case of domestic abuse? Is mediation possible? And I will let Melissa and Nathalie address that. Thank you.
I'm of the opinion that it is possible, but it takes a very highly trained and skilled mediator, and it takes a lot of work in advance to structure the process in a way that enables both parties to feel safe and to feel as if they have a voice in the process. There is a lot that happens in abusive situations that even a mediator is not understanding. It could just be a look between the two individuals. That could be an abusive look that we wouldn't see, but for, unless we knew the party's relationship. So it's a really highly intricate situation. But I'm one to say that mediation is private. In many situations, I found that survivors of domestic violence would rather participate in a private, confidential setting as opposed to testifying in an open court proceeding in the United States, where they're confronted by the person that may have been abusive. So I wouldn't want to be the person to say that, absolutely no, I'm not going to mediate for someone who's a survivor of domestic violence. It just has to be highly structured.
Yes, and in this kind of case, we always can have the help of psychologists, and yes, and white people in that way.
Before we turn to case study number 8, I have there is a quick question about how does the Hague Convention and other possible international convention treat those family cases in time of war. So,
I mean, I think you're probably referring to what's happening in Ukraine right now.
So.
I know at the beginning of March, the Ukrainian government indicated that they were no longer able to abide by their treaty obligations under the Hague Abduction and other conventions, which seems logical considering most Ukrainians are fighting in the conflict, including lawyers and judges. So it's if there is a child abducted into Ukraine, it may be very difficult procedurally in order to secure the return of your child through legal mechanisms, even though the Hague Abduction Convention is in place. But if the child, say, were abducted to the United States and a parent sitting in a location where there is a war is seeking the return of the child to that location, their habitual residence where there is war, that's a slightly different situation that would present whether or not returning the child would expose them to a grave risk of harm. I'm not sure if Richard had other thoughts on that particular argument.
I think that I can envision a situation where a child is brought to the United States now from Ukraine. And I don't know why anyone would want that child to return to Ukraine, but let's just say that were the case right now and someone brought an action here. I do think that there would be a strong argument to be made that it would present a child with a grave risk of harm. I did have a case many years ago with the Ukraine, and it was during a time where I think there were some Russian warships off the coast, and they had declared a state of emergency. And I know the other lawyer was raising the specter of using that as a grave risk of harm, which they later dropped because it didn't result in a full-out war. But certainly, I think this would be a very specific set of circumstances. There is a lot of case law that talks about the fact that grave risk of harm includes things like war, famine, disease, and those would be sufficient and strong enough to prevent the return of the child.
Thank you. Richard, you want to speak about case study number 8?
Sure. I think Melissa wrote this, and I think it's very fascinating. So that's why I wanted to go to this one before we run out of time, but Frances is pregnant with Lucas's child. Prior to learning of the pregnancy, the couple had decided to separate. They live in New York and have lived here for quite some time. Frances informs Lucas that she intends to give birth to the child in France. And I will say that there was a very famous case with an Olympic something or other, Olympic swimmer, skier, where in New York, where the mother was pregnant and the mother took the child to California, and a New York judge went very aggressive on her actions, saying, you know, how dare she go to California and violate his rights. And that case got appealed and reversed because during pregnancy, a woman has every right to go wherever she wants to go and give birth to the child wherever she wants to give birth to a child. And if she wants to give birth to the child in France, that's her right. She wants to give birth to a child in another state or another country, anywhere, that is her right. So until a child is born, the father has no rights to determine where the child should be living or residing.
But I presented this particular case study because I get this question all the time from individuals, mostly fathers, where the to-be mother is moving to another country to give birth to the child. And if there already are tensions between them and the child is born in the foreign country, the father may be beholden to the legal system of the other country. As Richard was saying on the last case study, if the child's born in that country, at least under the domestic law that we apply in the United States, that is where the child's home is. That's where their habitual residence is going to be. That's where we would determine is the proper jurisdiction to resolve custody over this child. And so even if the child, even if the father does not agree that the mother go and give birth in a different country, he can't necessarily stop her from leaving the United States. We don't have laws that would stop the free movement of adult individuals, short of criminal actions or immigration impediments. And she can go and give that. And this is also where mediation can be extraordinarily helpful. While courts in the United States are not going to necessarily be issuing custody orders while a child is still in utero, parents can start having that conversation about what their parenting plan will look like for when the child does come into this world, and what all of their situations will be, and reach certain agreements in advance, and even have legal counsel consulted before the child's even born in both applicable countries here in France and New York, so that both parents know that their rights are going to be protected once the child is born and that their agreement is going to have some legal effect.
There was a Hague case where a mother gave birth to a child in the United States, and the father tried to have the child returned to a foreign country, alleging that their plan and their intention was to raise the child in the foreign country. But because the child was born here, and saying that the mother came here to give birth, but that was not their agreement, but the mother, chose to come to the United States for whatever reason, give birth to the child, and continued to live in the United States. And the court found that because the child was born and lived their entire life, as short as it was, at that point, maybe months, that the habitual residence of the child was the United States.
Again, it's the responsibility of the parents and the adult to try to act in the best interest of the child.
Do you want to go on with case studies because we have a few more, or do you think we should close up with recommendation and tips? What do you feel like doing?
I vote for case studies. I think we've given a lot of tips along the way, but it's up.
Okay, good.
Hélène, you're the boss, so whatever you want.
So let's go to case study number 9. So Charles is a US citizen and Julia is a French citizen. They homeschool their children and they live 50% of their time in France and 50% of their time in the United States. They work remotely as well for their respective companies in France and in the United States. Julia realizes that she no longer wants to remain married and she wants to move back to France. Charles intends to file for custody in the United States where the children are currently located. It's a tricky one.
This screams for mediation in my mind, because I would not want to be the lawyer involved in a case like this.
Yeah.
I would say a judge doesn't want to be the judge to hear a case like this, because I'm not sure that I know what many judges would do in this. As the lawyer, as Richard was saying, I don't know that I could advise my client what the likely outcome is in this particular case. I could say what legal arguments I would make on their behalf, but I can't say that they're necessarily winning arguments, because I could see it going either way.
And there was a Hay case where the children were homeschooled. I took this from a Hay case where the children were homeschooled and split their time 50-50 between a foreign country and the United States, and the parties moved back and forth. And in that case, I think that the deciding factor really to determine that the United States was the habitual residence, aside from the fact that the case took place in the United States, so perhaps there was some incentive to have the children remain here, but was that the children were being homeschooled pursuant to a United States curriculum. You know, so just little things like that could be important. But this is a very complicated situation, and certainly one that, you know, might benefit from a skilled mediator.
That's what we with like choosing to live 50% of the time in France, 50% of the time in United States. You can choose that for the job, for your job, for the country where you want to live, but you cannot choose that with the children, to have them 50% of the time and give it to the 10% of the time. So
although I have had parties in mediation agree to something like this.
Me
The
too.
homeschooling, international baccalaureate schools, French schools that have the same curriculum, where parents do agree that the children would go back and forth on a very routine basis and still have a very consistent curriculum. But that is only one component of it. You might be able to get a cohesive education, but the question is how is this particular child actually addressing it socially? How is their health and flying so frequently and changing time zones so frequently? I mean, there are a lot of questions that are more child focused that I think the parties would need to think through, the parents would need to think through before they would reach this type of agreement.
it's a very, yes, it's a big deal, and it's a big challenge that you impose to the children. But it can arrive. I've seen that like 1 year with the father, 1 year with the mother, but at the moment the children say stop.
Yeah, so, but that's why, because maybe it works for a while, and maybe even the parents, you always said that mediation, you have to see mediation as a long-term process also, and maybe at one point the parents understand that it's not working, you know, in the long run. I think it's 4:58, so I think we should maybe end this presentation. I was so happy to have all of you here. I hope it was helpful for the people who listened to it or who will listen to it, hopefully. And I don't know if the consulate is going to provide our contact information if people need to reach out to amazing mediators and amazing lawyers. Yeah, in any case, get the
I want to thank all the participants and the panelists. It was very insightful, and it's a very important topic, especially for binational families or families French families expatriated in the United States. And I want to say that if someone is experiencing that his child has been abducted, or think that his child is in danger of being abducted, they can always reach out to the consulate, to their consulate. And they should not hesitate to contact the consulate that will provide information and a list of French lawyers. And the conference will be available in replay on the websites of the French consulates in the United States, so people can have a second look at it or a first look at it. And really, thanks to all of you for participating and giving us so many advice.
Thank you. Bye-bye.
Bye-bye, everybody. Thank you, Hélène.
Thank you.